Hey guys, we're studying witnesses in chapter 6 of your textbook this week in criminal evidence. Be sure to read the material before taking the quiz. My attempt in this lecture is to make your reading a little easier to understand. So let's go over a few things that may help. Roger Clemens, winner of 7 Cy Young Awards, testified before a congressional committee in 2008 that he had not used steroids or human growth hormone. Now, later, Brian McNamee and Andy Pettit testified that he did. The congressional committee asked the Justice Department to investigate. In August 2010, Clemens was indicted on 3 counts of making false statements, 2 counts of perjury, and 1 count of obstruction of Congress. In this chapter, we'll study a lot regarding the weight of testimony, who determines that weight, and impeachment of that testimony. This case will help you to understand some of these issues. The case actually went to trial in July 2011, but a mistrial was declared on the second day of testimony. What happened was a document that the judge had ruled that the jury shouldn't see was left on the prosecution's monitor, and that monitor was clearly visible to the jury while the judge met with the attorneys in his chambers. So that trial was declared a mistrial. The second trial began in April of 2012. The prosecution called 23 witnesses. It introduced videotapes and transcripts of Clemens' testimony before Congress. A deposition during which Clemens acknowledged receiving injections of vitamin B12 and lidocaine, but he denied receiving banned drugs. That deposition was introduced into evidence also. The former friend and teammate Andy Pettit testified in 2000. Clemens told him that he used HGH, but 5 years later, Clemens denied that he had made that statement. On cross examination, this was particularly interesting to me. Pettit was asked how confident that his memory of the conversation was correct, and he said 50-50. the the prosecution team had to cringe when he said that. Defense attorneys asked the judge to strike all of Pettit's testimony because of his uncertainty, but the judge ruled that the jury should decide on what to believe. And you'll see this a lot. Whether it's 50-50, 70-30, 80-20, or 100%, the jury is the one that decides who they believe and who they don't believe. Now, another witness, Kurt Radomski, testified that he sold steroids and HGH to Brian McNamee, who was Clemens' strength coach at the time. Radomski later admitted that he faced a possible 5-year prison sentence for a previous crime, but since he cooperated with the Clemens investigation, he only got probation. So again, the prosecution had to cringe. These things they had to know going into trial, but I don't know if they knew the defense team would bring it up, or if they knew the defense team would do their due diligence to find out and try to impeach the testimony of these witnesses. But obviously they did. Also, McNamee appeared nervous when he was testifying about numerous occasions when he gave Clemens injection of banned drugs. McNamee had given the prosecution team some evidence to use against Clemens, but during the cross examination, he admitted the evidence could have been cross contaminated with other athletes that he was representing. At the end of the trial that lasted 9 weeks, the jury deliberated for 10 hours before finding Clemens not guilty on all counts. What do you think happened here? Do you think that Roger Clemens used banned drugs during his career in the major leagues? How important is the testimony of witnesses, and how important is that their testimony is believed? To me, if I only looked at the evidence put in front of me at trial, I'd feel like Roger Clemens was targeted by the government for his testimony before Congress. I also feel like the witnesses the government put on the stand were shady people, and with these shady personalities come less than believable testimony. I think the jury couldn't put Clemens in jail for the evidence that was put before them. The standard of beyond a reasonable doubt was not met. Now, did Roger Clemens lie before Congress? He probably did. But in trial, you've got to prove these things. So I think In this chapter, I hope you understand what an incompetent witness is also, and it kind of relates to the trial that we just went over. Understand what impeaching and rehabilitating a witness is, state the opinion rule. What are the prerequisites for allowing an expert witness to testify? What can a lay witness testify about? Let's go over a couple more things before we wrap it up. Let's discuss what an incompetent witness is. So, if a witness can be incompetent, what makes a witness competent? And that's what we're looking for. A person who understands the duty to tell the truth and can narrate the events in questions. That's a competent witness. Now, if you can't do these simple things, you would be an incompetent witness. So, and that's what prosecutors and defense attorneys are looking for when you're looking for witnesses. You're looking for those that can do those things. Now, when I think about impeachment, I'm thinking about throwing out completely. So, if you think about an impeachment of a president, you're throwing that president out, or anybody in a public office, they're gone. But in a sense of testimony, impeachment means that you're simply lessening the probability that they're telling the truth. So, and that's what the other team is always going after. So, impeachment is one of the key functions of cross examination, where you try to convince the jurors that they should not believe the other side's witnesses. In some cases, witnesses may solely be called to testify simply to impeach the testimony of earlier witnesses. So, here you may call, if someone testifies to something, someone else may know that their testimony is not true. So the other team, the defense or the prosecutor, will call someone up there to testify to show that they're not telling the truth, hopefully, in an attempt to impeach that testimony. Um, Now, rehabilitation is the restoration of the credibility of a witness. So once a witness has been impeached or their testimony is less than believable, that side will try to the side that originally called the witness will try to convince the jury that the witness testified truthfully and it should be believed. Attempts to rehabilitate witnesses are done during redirect examination. So remember that. Attempts to rehabilitate witnesses are done during redirect. Um, I also want you to understand what an opinion rule is. Opinions of the witnesses are not admissible because it's the function of the jury or the judge. If the case is tried without a jury, it's up to the judge to decide what the opinions are and to analyze the evidence, not someone testifying. So in practice, however, a lay witness, they're generally not permitted to state conclusions, but expert witnesses may give their professional opinions. So what is a lay witness? It's simply a person who observed an event that is relevant to the case on trial. Lay witnesses are allowed to testify about any relevant event that was observed with one or more of the five senses: sight, hearing, smell, touch, and taste. Other than that, they can't give an opinion. So you have a lay witness, but what's an expert witness? An expert witness is called to help the jury understand the evidence, and they're only allowed if the facts cannot be understood by the jurors without their help. That's the only time an expert witness is allowed to testify. Some expert witnesses require extensive education, whereas others are based on specialized training and experience. Now, what I always wondered, who decides if a witness is an expert? And it kind of surprised me in law school that most of the time no one decides. So if a defense attorney wants to put someone up there and say that they're an expert, uh, if they've got an expert opinion on a particular thing and they're an expert in this field, if one side puts them up there on the stand, it's the other side that actually must do their due diligence to impeach their testimony. So if someone put me for those of you that don't know me, I can't work on cars at all. I don't know anything about vehicles. So if someone put me on the stand during a trial that required knowledge of the workings of a motor, and I got up there and I said I'm an expert on motors, and I told about motors in a way that this person wanted me to say it. Now, the other side would have to come back and say, well, tell me how you know about motors. And after a few questions, they would know that I don't know about it. And my testimony and me would be impeached. It doesn't take much. The judge isn't going to look at what the person has done. It's the other side's duty to impeach. So I hope this helps. Let me know if you need any additional directions, and have a wonderful week. Thank you so much.